Welcome again to everyone who is able to join us today. This is our presentation on private offerings using Regulation D and intrastate exemptions. My name again is Patrick Haddad, and I am a partner with the Kerr Russell Law Firm in Detroit. So without further ado, we have the presentation on the screen now, and hopefully everyone can see it, and hopefully everyone can hear me. If there are any issues with audio or video, perhaps use your question and answer queue to alert Linda to that. The screen we're looking at now shows the topics that we are going to discuss today. I'm going to take you through some background considerations. We'll chat for a bit about intrastate offerings, Regulation D offerings, and then at the end we'll save some time for question and answers. So the next slide is simply showing a background of relevant laws. What you have in front of you now is a summary starting out with various federal laws. And the Securities Act of 1933, that is a federal law that regulates the sale and offering of securities. Because it's a federal law, it applies nationwide. The tie to commerce is really what gave the Congress the authority to enact this legislation. And there's various rules that are promulgated under this act by the Securities and Exchange Commission. The SEC, headquartered in Washington, is the agency of the federal government which is charged with oversight of the Securities Act of 1933 as well as the other federal securities laws, many of which are not referenced here in this slide. In terms of rules that are issued and on the books by the Securities and Exchange Commission, you have a few of them that are listed on the screen. One is referred to as Rule 147, and that rule provides an exemption for offerings that take place solely within state boundaries of a given state, and there's various criteria that goes along with that, and we're going to talk about that in a bit. Another common federal regulation that is often utilized is referred to as Regulation D, and there are various alternative rules under Regulation D that provide a basis for exempting an offering from registration with the Securities and Exchange Commission. There are rules 504, 505, and 506. Rules 504 and 505 are somewhat limited in that they have caps on the dollar amounts that can be raised over certain periods of time and other limitations, and at least in my experience are not all that commonly utilized, whereas Rule 506 is much more elastic, has no limitation on dollar amount, and is very frequently used. So a little bit later in the presentation today, we're going to talk in more detail about that. Next listed on the slide is a reference to the Michigan Uniform Securities Act, and that is the state of Michigan's Securities Act. That act regulates various aspects of securities, which takes place here in Michigan. The part that we will be concerned about today is the offering of securities and registration and the like. But be aware that the Michigan Act, like the acts in other states, also regulates various aspects bearing on securities, such as broker-dealer registration, investment advisor registration, and the like. And that's kind of a good segue to the final bullet point on the slide, which is there are various laws, both federal and state, that regulate and provide exemptions from regulation for various practices that certainly bear on offering, selling, and buying securities. We'll talk more about those at the appropriate time during today's presentation. And the takeaway for now is simply to be aware of. The next slide is entitled Offerings, and this is kind of a brief overview, and some of this might seem obvious, but I think it's worth pointing out that an offering of securities is really a process. It has a beginning, a middle, and an end. It really is not a one-time static event. Each aspect of the offering is subject to legal regulation, and there are various sources of legal regulation. One source is by statute, and a related source is by administrative rules. So on the previous slide, reference was made to various federal and Michigan statutes as well as regulations, and that's what this part of the offering slide is really referring to. But in addition to that, offerings are really regulated as well by contractual agreements between the issuer of the securities, so that's the company, the person who is raising capital by selling securities, and the purchaser of those securities. Each aspect of the offering phase is going to be regulated in one form or another by one of these different sources. And just to sidebar for a few minutes, at the very beginning of an offering, when a company, an issuer, is starting to structure the process, determine what it needs to raise, how it needs to raise it, and so on and so forth. Really what has to happen is there has to be focus as to each phase of the offering and how it's going to be conducted and how it's going to be documented. In terms of what it is that one offers, there's various types of things, if you will, that can qualify as securities that are subject to regulation by the securities laws. Some of the more common items are listed on the presentation right now on the slide. Common stock and preferred stock, those are pretty much obvious items that will often qualify as securities for this purpose. Likewise, limited liability company membership interests and units will qualify as securities, as will partnership interests. Promissory notes and other debt instruments will also qualify as securities in many situations. This should be distinguished from conventional bank lending, which is oftentimes documented by a promissory note and other instruments, but in those situations that really is not intended as a form of a security as between the organization making the loan, so a bank or a credit union, and the borrower. So for example, when one is obtaining a mortgage loan for residential purposes. However, if and when the lender turns around and packages and sells those obligations, then that total package will most likely qualify as a security. And finally, there is a catch-all category which is referred to as investment contracts. And, sometimes a business arrangement that one is putting together may very well qualify as an investment contract, an annuity. It can take on many different shapes and forms. So that's just one thing to be aware of, is that although one may not necessarily think of an obligation or an instrument as qualifying as a security, it may very well qualify as that and be subject to regulation. In terms of who it is that issues securities, it typically is going to be an organization. So, for example, a business corporation, the types of corporations that can do this may be incorporated in Michigan, they could be Delaware corporations, they could be incorporated in any state, and they could also be foreign organizations as well. Limited liability companies are also issuers of securities for our purposes today. Although it's not all that common, you will see limited liability companies that are the issuers of securities of publicly traded companies. And finally, partnerships can also qualify as issuers of securities. With the advent of limited liability companies, it's not all that often to form true partnerships today, but one can certainly do that, and there's certainly reasons why one would consider doing that. So just take away that there can certainly be situations in which any of these types of business organizations can issue securities. And I did not list on here nonprofit organizations, but keep that in the back of your minds as well. Certainly a nonprofit could do so. And also keep in mind that every nonprofit corporation is not necessarily a tax-exempt organization. In other words, not necessarily exempt from income and other taxation under the Internal Revenue Code. There are certainly many nonprofit corporations which are taxable organizations. In terms of the offering process, one thing that needs to be thought through is how the offering is going to be documented, because offerings are really transactions where there is an offer, a sale, and a purchase of securities. What is listed on the screen now is a smattering or fairly typical laundry list of offering documentation that one would typically tend to see in a given offering. In terms of does this list have to be satisfied in each and every offering? Well, not necessarily. A lot of it's going to depend upon the size, the cost, the complexity, and the like. Let me speak for a few minutes as to what each of these documents are all about. The first one listed is a confidentiality agreement, often referred to as a non-disclosure agreement. And the reason for really putting this at the top of the list is because when a business organization is thinking of raising capital by offering securities for various reasons having to do with compliance with the exemptions that we're going to be speaking about, one most likely will not be able to engage in public solicitation or advertising of the offering, and having a confidentiality agreement in place is one way in which, one technique that's used to document that. In addition, there may be business or proprietary reasons on the part of the issuer in terms of giving access to its information about its business, its operations, its affairs, its business plans, and the like, and it legitimately will want to maintain confidentiality and certainly share and make that information available to investors who are interested in looking the company over before deciding whether to invest, but the company will have a legitimate interest in wishing to limit the access to that information to that purpose. The next document is an investor presentation, and many times this is simply a PowerPoint presentation which kind of puts the facts in front of the investor. A picture is worth 1,000 words oftentimes, and it really is nothing more than just laying out who the issuer, the business organization is, what it is they are seeking to raise, telling the investor information about the business and the business plan and where they are and where they hope to be, and so on and so forth. A term sheet is really a document that is going to lay out the specifics of what the proposed transaction is. So, for example, are we proposing to sell stock? If so, we are selling it for cash, and what is the price going to be per share? Is there a minimum or a maximum that investors will be permitted or required to buy into? Just all those basic details of the nuts and bolts of, what is the business transaction. And another item that will commonly be laid out there will be, the transaction documentation that would need to be signed and who it needs to be furnished to and when and the like. Another common issue that will be addressed in a term sheet is whether or not there is a placement agent or a finder or other person functioning as a broker who's going to be compensated and what that compensation will be. Additionally, the use of proceeds will oftentimes be laid out in there. In other words, of the money that's going to be raised and net of commissions payable to placement agents, how is that cash going to be used? Is it going to be used for general corporate purposes or more specifically to purchase plant and equipment and the like? The information memorandum is also commonly referred to as a private placement memorandum, and it really is a disclosure document that lays out in much more detail than the term sheet who the issuer is, what its business operations are, detailed information about the offering. So kind of picking up on what I said relative to the term sheet, but just going into more detail. If the company is established, oftentimes there may be financial statements or financial information made available in the information memorandum and the like. From a regulatory standpoint, a key reason why you will often see an information memorandum used is because the issuer wishes to make disclosures not only in order to educate the potential investor and in order to sell the offering, if you will, but more importantly from a liability standpoint to make the disclosures that are necessary due to potential anti-fraud liability. We'll talk more about that a little bit later, but essentially, in addition to seeking to comply with the standards necessary to exempt an offering from registration, one also needs to disclose certain types of information. Think of it as information that a reasonable investor, the hypothetical reasonable investor, would wish to know in order to make an informed decision before purchasing the securities. And if there is a flaw or defect in the furnishing of that information, and if it turns out that the company is not what its promoters promised it to be, there can be liability on their part for having failed to disclose that kind of information. So that the vehicle for making those types of disclosures will often be an information memorandum. A securities purchase agreement is really essentially that. It's an agreement that documents the sale and purchase of the securities, and oftentimes the details will be in there regarding what the security is, what the price is, what the quantity is, so on and so forth. And in addition, there will typically be various representations and warranties in there that are made on the one hand by the issuer, so representations and warranties regarding the truthfulness and accuracy of the information disclosed in the information memorandum. And on the other hand, there will typically be representations and warranties in there regarding the purchaser, that the purchaser has received and reviewed all of the informational and disclosure documents, is satisfied with its receipt of that information, has no unanswered questions, and additional representations and warranties along those lines. Our theme during our presentation today is really speaking about offerings that are exempted from registration under the securities laws, and consequently, an issue in any exempted offering is whether or not the issuer is going to contractually commit itself to registering these securities for resale by the individuals who purchase those securities. I'm getting a little bit ahead of the presentation right now, but essentially, unless the issuer contractually commits itself to registering these securities, then the purchaser of those securities, the investor, will likewise have to sell the securities when he or she desires to do so, and if permitted to do so, on an exempted basis. And generally speaking, there will typically tend to be one or more exemptions, both under state and federal law, that will be available for that purpose. But there can also be contractual restrictions on the ability to resell. And those contractual restrictions may be contained in some of the documents that are referenced on the screen, or possibly in the form of what is commonly referred to as a shareholder or security holder agreement. In addition to everything we've gone through so far, typically there will tend to be some sort of certificate or document that evidences the securities that are acquired, such as a stock certificate. If one is acquiring limited liability company shares, those shares will typically be evidenced by the investor's signature to the company's operating agreement. There will not necessarily be a separate security certificate if one is acquiring a limited liability company interest. In addition to the securities certificate, there will typically be one or more regulatory filings, and I think we have these listed later in the presentation. Depending upon the basis or the exemption that is being relied on, that will determine what needs to get filed and with whom and by when. And finally, if there is a placement agent, someone functioning as a finder or compensated placement agent, and typically individuals doing this will be securities professionals who are associated with registered broker-dealers, there will typically be an agreement between the company and that person's firm providing for compensation in exchange for the services that they are going to be rendering. And typically those compensation arrangements will be a fixed percentage of the gross amount of capital that's raised in the offering. The next slide is going to furnish some examples of offerings, and for the most part what I've been speaking to has been in the context of a capital raise transaction. So in other words, the purpose of a capital raise offering is just that, to sell securities in exchange for cash for the purpose of raising capital. So one of the issues that kind of goes along with that and that the investor would want to be aware of is what is the use of those proceeds after the expenses of the offering. What uses will the company be making of those proceeds? From the company's standpoint, the company is typically going to want to have a lot of flexibility. So oftentimes you might see language describing the use of proceeds as being for general corporate purposes. Other times there might be a more specific purpose enumerated as well, as I mentioned previously, to acquire or build a new plant, to acquire equipment, and the like. In contrast to a capital raise transaction, a different type of transaction will be compensatory in nature. So, in other words, the goal of the offering is the company wishes to award common stock options or restricted stock or other securities to its employees as compensation for services rendered. There's going to be a different array of documentation that will be used for that purpose, and there will be different exemptions that will be relied upon if that offering is going to be exempted from registration, which it often will be in the case of a private company issuer. And in the case of a public company issuer, those offerings typically will be registered. And I simply wish to point out for your benefit now, if you're not fully aware of this, that if one has or is planning on compensating employees of your organization with options or stock or other securities, bear in mind that those are transactions in securities. They are subject to regulation, and it's something that one is well advised to consult with a knowledgeable attorney on to make sure that it is done appropriately. The final item that's referenced here refers to security holder transactions. So the first two sets, capital raising and compensation, is really referring to transactions that the company, the issuer of the securities, engages in. The final bullet point is referring to transactions that the investors, so the shareholder of a company, for example, desires to sell the stock that the individual owns for cash in order to gain liquidity. That transaction typically is going to qualify for an exemption from registration under both federal and state law. Which exemption is relied on will depend upon the facts and circumstances. And in addition to needing to proceed along an exempted basis, if that's the situation, or a registered basis if the resale transaction happens to be registered, one needs to also bear in mind that when the securities were originally acquired, the company and other shareholders may have entered into an agreement that sets out the terms and conditions under which one can sell the securities that were acquired. This will typically be an issue among privately held corporations, typically closely held corporations where you have smaller groups of shareholders. The next slide is, again, stating out from a high level something that might seem obvious, but I think this is a good takeaway in that it will help one remember that an offering of securities, you really have three choices. The offering is either registered, it either is exempted from registration, or it's illegal. In terms of the last category, we have some information about the consequences of illegality coming up soon. But if you think of it, just keep these 3 points in mind. I think it'll just help you kind of navigate the waters or understand what the different channels are when you're navigating these waterways. Registration, whoops, got ahead of myself. Registration is really a process that has both a federal aspect and a state aspect to it. If an offering of securities is to be made to the public, it needs to be registered. And what comes out of that entire process, which takes on a life of its own, by the way, is a disclosure document. That disclosure document is typically called a prospectus. It contains information along the lines of what I had mentioned, from a private placement memorandum, but it typically will require audited financial statements and a whole array of other information that goes well beyond what one would typically see disclosed in a private placement exempted offering. For that reason, and because registration is very costly, not only in terms of legal fees, but also in terms of accounting fees and the time requirements for the company, it very typically is going to be cost and time prohibitive for startups and for many other businesses that are privately held. So consequently, our focus during today's presentation is not on registered offerings, but rather is on exempted offerings. In terms of illegal offerings, don't be confused and think that illegal offerings are necessarily criminal matters. They're not. Sure, we all read about the Ponzi schemes and other flat-out criminal fraudulent matters, but that's really not my intent to address those situations. When I'm referring to illegal offerings, what I'm really referring to is an offering that technically fails to satisfy the criteria for exemption from registration and likewise has not been registered, and consequently, strictly speaking, that offering is illegal. So the question becomes, gee, what are the consequences if we've had a flaw in the exemption process and it doesn't qualify for an exemption? There are various remedies that are available to investors in those situations, and that includes a right of rescission. If an investor does have a valid rescission remedy, then the company repays the amount invested less any amounts of income. So, for example, dividends that may have been paid. The issuer has to pay interest relating back to the time that the investment was made. The investor has to return the securities, and all of this may very well need to be disclosed in offering documents to the investor, giving them the opportunity to make an informed decision whether to rescind or not. That's what happened, for example, when Google some years ago filed its initial public offering paperwork. They had to undertake a rescission offering because the compensatory awards of their own securities that they made to their employees technically did not satisfy the criteria for the relevant exemptions. So as part of pursuing their IPO, the SEC required them to undertake a rescission offering to their employees. In terms of what else can happen, in addition to private remedies available to investors, there can certainly be enforcement action by federal and or state regulators. This could certainly result in some liability exposure to the issuer as well as to its promoters and directors and officers. I mentioned previously anti-fraud obligations, and that's one additional compliance obligation to note on the slide in front of you. Again, the concept there is that the measuring stick of the adequacy of the disclosures that are made to investors is not limited to what's necessary to satisfy the criteria for an exemption from registration, but one also needs to make such disclosures as a reasonable investor would wish to be made aware of, so that neither by what is disclosed nor by what the issuer fails to disclose is materially misleading to the investor. And the standard by which that is all measured is a reasonable, objective investor. It's not what any one specific person may or may not think, but it's that hypothetical, reasonable investor. So the offering process and the disclosures that are made have to take all of that into consideration. In addition, there are various federal and state laws that regulate a whole array of other aspects of this. So there is both federal and state regulation of individuals and organizations that may function as broker-dealers. And broker-dealers, whether it's your garden variety brokerage firm or a smaller organization that is doing more of a niche business, they may very well need to qualify and register as broker-dealers. There's an important point here for the directors, officers, and employees and promoters of the issuer of the securities, because if they're not careful and if they are being compensated, which they normally should not be, for assisting the issuer in raising capital through an offering of securities, they may very well trip the line and be subject to registration as a broker-dealer. And if they have crossed the line and are not registered as a broker-dealer, then they will have a liability exposure for having violated the relevant state or federal laws. So that's one of the important things that has to be taken into consideration at the outset of structuring an offering, is as to what role the directors, officers, employees of an organization are going to play, and reviewing with them the do's and don'ts so that they don't unwittingly cross the line. Likewise, compensatory arrangements for finders may also be subject to regulation both at the federal and state level. The SEC has its views, which are available on the web, regarding circumstances in which individuals and organizations may functioning as finders. So in other words, assisting the issuer in locating individuals or organizations that are interested in investing. And the authorities that you can look up online will speak to the circumstances in which people functioning as finders and who are compensated may or may not need to be registered as broker-dealers or as investment advisors, either with the SEC or with the state securities regulators. And in Michigan, there have been some developments by way of case law concerning those compensatory arrangements and registration issues, and they are also spoken to in the Michigan Securities Act. An important takeaway is that making sure that one understands where the minefields are is very important, whether the offering is registered or exempted from registration. So in addition to being aware of the lines of demarcation for broker-dealer registration, there's a whole extensive array of regulation that applies to companies that are going to function as investment companies that are regulated by the Federal Investment Company Act of 1940, and typically, unless an organization is formed for the purpose of acquiring and investing in the securities of other organizations, there typically is going to be an exemption available from that set of legal regulation. And another set of legal regulation, this again bears on the person who is assisting in the offering, is whether or not they will function as an investment advisor, which again is subject to regulation. This is a little bit more detail on anti-fraud obligations. I have largely spoken to this. I won't spend much time here except to again emphasize that one needs to carefully assess the array of items of information that are disclosed, as well as informational items that are not going to be disclosed, because anti-fraud liability exposures can arise either by way of affirmative statements as well as by way of omissions. and we just have some additional information that goes on in more detail on the anti-fraud obligations. The next slide is speaking to intrastate exemptions, and basically this is an exemption available from the federal securities laws, the Act of 1933. And basically, if exemptions are taking place within the geographical boundaries of a state and are made only to persons resident within a state, and if the other criteria is satisfied, then that takes the offering of those securities outside the realm of federal registration. And the basis for this is both the federal statute as well as SEC Rule 147 that has various standards relating to the revenues and assets and proceeds of the issuer and the offering, and also resale restrictions. Regarding Michigan, the tie to the Michigan Securities Act is that if a offering is exempted under the federal intrastate exemptions, then one needs to look for compliance or an exemption from the relevant Michigan exemptions. And what I've noted on the slide is a couple different Michigan exemptions that will typically be looked to, and I'll go over those in a second. And the last reference to the Michigan Invest Locally exemption, that's Michigan's version of crowdfunding. There should be another presentation that's available on the web regarding crowdfunding, and crowdfunding has both a federal aspect to it that will become effective in a few months, and it also has an alternative Michigan crowdfunding, and that's what Michigan Invest Locally is referred to. I'm not going to go into more detail about that because crowdfunding is really its own topic, and as I mentioned, there should be another presentation from one of our other speakers available on both federal and state crowdfunding. The Section 201N exemption is what one typically will look to under Michigan law to exempt an offering, and it is fairly elastic. The key criteria is a limitation on the number of purchasers in any 12 consecutive months, no general solicitation or advertising. There can be no payment of finder fees other than to registered broker-dealers, and investors must purchase for investment purposes and not for a purpose of reselling. In other words, the offering cannot simply be a conduit to make a public offering of the securities through what otherwise purports to be a private exempted offering. As an alternative to that, there is another exemption available under Section 201M of the Michigan Act, which is typically limited to institutional type advisors such as banks and insurance companies and the like. The Michigan Invest Locally exemption, I do provide some information, but as I mentioned, I'm not going to go over that so that we can segue into Federal Rule 506B. So if one is able to rely on Rule 506B, one only needs to look to that exemption and its criteria, which have both exemptive standards as well as anti-fraud standards. And a Rule 506B offering preempts state regulation of the offering, meaning that it is not necessary for one to comply with additional state exemption standards, but the states are certainly entitled to require notice filings and the payment of any fees that go along with that, and Michigan is one of the states that does require that, which is very common, and there's more information about that in the slide. One thing to note is that Rule 506B is not available if certain of the executives, the officers, the directors, beneficial owners of 20% or more of the company have had any convictions within the last 10 years before the sale related to securities violations. If that's the case, then this exemption is not available, and typically this will be documented by way of a affidavit or questionnaire that each one of those individuals would fill out to confirm that none of that applies. This exemption is available only to accredited investors as well as to a limited number of non-accredited investors. The criteria for accredited investors is specified on the slide now and essentially is limited to high net worth individuals. Also, organizations and corporations can qualify as well as certain insiders of the company. There are general standards that apply to any 506B offering, and there can be 35 non-accredited investors. And in addition to that, there are certain standards that the non-accredited investors would have to satisfy. And the way that one documents whether they satisfy this is through the offering documentation that I had mentioned at the beginning of the presentation. In terms of other standards that need to be complied with, there is a filing that has to be made with the SEC, and that has to be made electronically now, and there is some time that's required in order to get the filing codes for that. So given that the Form D has to be filed within the 15 days following the first sale, one needs to timely ensure that the filing codes are available. And there is a paper copy of that that gets filed with the state security regulators, as well as a filing fee, and the information relating to Michigan's requirements is listed there. One thing to bear in mind is that the securities that are acquired in a Regulation D offering are restricted, meaning that the securities laws require them to be held for certain minimum time periods before they may be resold. And in addition to that, there may be contractual restrictions that the investor has agreed to as well. The SEC restrictions are listed on the slide on the screen now. There is a fairly new federal exemption under Rule 506C. Rule 506B does not permit general advertisement and solicitation, so in other words, does not permit advertising. There is an alternative, 506C, which does permit solicitation, for example, marketing over the Internet. However, it is limited to accredited investors, so whether or not it's going to be an appropriate choice for a given offering will have to be evaluated at the right time. So we're nearly at the end of our hour's presentation today, and I suppose at this point, if there are any questions that anyone wishes to raise, we can take a few of those at this time. And my contact information is presented on the screen now, and certainly anyone who has questions afterwards is welcome to get in touch with me at the office.
Well, I want to thank you, first of all, Patrick. This is probably one of the most thorough presentations I have ever seen on Regulation D. It would be difficult for me to think of any question that you actually haven't incorporated into the presentation and answered already. It was excellent. Thank you so much.
You're welcome. Thank you, Linda.
I will go ahead and do my closeout. If there is a question that comes in, I will forward it to Patrick after the presentation is closed to the email that's there so that we can keep this on track and on time. I want to start by saying thank you to all of you for joining the first of our 6 Lunch and Learn webinars. We hope you enjoyed it, and we want to thank Patrick Haddad for taking time out of his busy schedule to share some very important information with us. I want to remind everybody that a recorded version of this webinar will be available for viewing at www.michigan.gov/securities in approximately 2 weeks. Our next webinar is scheduled for March 30th, and it will feature James Carey of Carey Law Offices and Michael Marsalis of the Marsalis Law Group. They will be covering the new Regulation A+. Some of you may be aware that the Securities and Exchange Commission recently adopted final Reg A+ rules to facilitate smaller corporate access to capital. The new rules update and expand the current Reg A, an existing exemption from registration for smaller issuers of securities. The updated exemption will enable small companies to offer and sell up to $50 million of securities in a 12-month period. We have had new businesses use the new Reg A+ in Michigan, and we are getting a lot of questions from entrepreneurs who want to use it and just don't understand how. Our next webinar will answer all of those questions. And one last reminder that our upcoming live seminar will be in Troy next week if you would like to sign up. The seminar is free, and breakfast and lunch are included. Once again, I want to thank Patrick, and I want to thank all of you for joining us, and have a nice day.
Thank you.
Thank you.